𝖕𝖊, Mr. VP, I believe in each one teach one. I don't mind teaching you, and I don't mind explaining because I'm never too old to learn and never too experienced to gain knowledge. So let's slow this down because what you just said sounds confident, but it's legally and contractually incorrect. You're asking how someone can file a contract grievance involving what you're calling a constitutional issue. The answer is simple, and it's actually written directly into the agreement. Article 2, Section 2.1 defines a contract interpretation grievance as a complaint involving the interpretation, application, or claim breach of the agreement. That's the standard, not opinion, not preference, not what someone thinks should qualify. If the issue involves how the agreement is applied, it is a grievance. Now let's walk through what Section 2.1 actually does, because this is where your argument falls apart. Section 2.1 doesn't just define the grievance. It establishes the entire procedure. Step 1, department level hearing. Step 2, labor relations review. If unresolved, submission to the impartial arbitrator. And once submitted, the arbitrator issues a determination on the interpretation, application, or claim breach of the agreement. That determination is final and binding upon both parties. That's not optional. That's the contractual system. Now let's apply that to what actually happened. The agreement recognizes the union as the exclusive representative in the grievance process. That means representation is structured, defined, and part of how the agreement is applied. Not informal, not interchangeable, not subject to management direction. Now, here's where the confusion comes in. The TWU Constitution and local bylaws are not the claim. They are the evidence. They establish what the proper representation structure is supposed to be. For example, Local 100 bylaws and Article 19 prohibits bypassing the duly elected grievance structure. So when management at Jackie Gleason tells me that he does not have to respect my position or title, that prevents me from representing members. He is directly interfering with who represents employees in the grievance process. And that conduct, Mr. VP, has to be evaluated against an established structure. And once that structure is interfered with, the question becomes very simple. Does that interference affect the application of the agreement under Section 2.1? The answer is clearly yes, and arbitrators will agree, because representation is not separate from the grievance procedure. It is part of the mechanism through which the agreement is enforced. So let's call it what it is. When management bypasses elected representatives, inserts or directs representation, and or undermines the established grievance structure, that is not a constitutional issue. That is interference with the grievance procedure, interference with the representation rights recognized under the agreement, and a dispute concerning the application of the agreement under Section 2.1. And that is exactly what Section 2.1 is designed to address. So let me make this clear. I'm not enforcing the Constitution through the CBA. I am proving the agreement was not properly applied and the Constitution and bylaws are being used as evidence to establish what the correct structure is. That's standard arbitration practice. Arbitrators routinely examine governing documents, define representation structures, determine whether contractual rights were properly applied. They don't enforce internal union rules. They determine whether the contract was followed. And once management inserts itself into that structure, it stops being internal, because now it directly affects how the agreement is applied through the grievance procedure. Which brings it back to Section 2.1. This isn't a theory, it's labor law. Under 𝖊𝖃 v. Sipes, representation cannot be arbitrary or undermined. Under federal labor law, employer interference with representation is prohibited. And under NLRB v. J. Weingarten Incorporated, representation in workplace proceedings is a protected right. That's on the back of everybody's union's card, except for mine because I don't have one. And arbitration itself is not optional. Under United Steelworkers v. Warrior and Gulf Navigation Company, disputes involving the application of a collective bargaining agreement are presumptively arbitrable unless clearly excluded. So let's apply it plainly. If management interferes with who represents employees in the grievance process, they are interfering with the application of the agreement itself. And under Article 2, Section 2.1, that is grievable. So when you say union issues and CBA issues are separate, that sounds clean, but it's just not how the contract works. They overlap, whenever representation is involved, the grievance procedure is involved, and or management interacts and interferes with the union structure, which is exactly what happened here. Let me simplify it. This is not using the CBA to enforce the Constitution. It's using the Constitution to demonstrate that the agreement was misapplied. And here's the real issue. If management can decide who represents employees instead of the union's elected structure, then the grievance procedure outlined in Section 2.1 is no longer being followed. It is being altered. And the agreement does not allow that, regardless of how it's being framed. So either there's a misunderstanding of how Section 2.1 actually functions, or there's an understanding and an attempt to dismiss how serious that interference actually is. Because if this stands, it establishes interference, it establishes an improper practice, and it establishes a breakdown in how the agreement is applied. And that's not a constitutional issue. That's a contract interpretation grievance under Section 2.1, an arbitration issue, and potentially a legal issue. Respectfully, this isn't confusion on my end. It's a misreading of the agreement on yours. And Section 2.1 makes it very clear. So the real question becomes, how does the GS make a statement like that with confidence? Because the agreement does not support it. And if the agreement doesn't support it, then one of two things is happening. Either there is a fundamental misunderstanding of how the grievance procedure actually works under Section 2.1 on his end, or there is a level of comfort with allowing the grievance process to operate outside of the structure required by the agreement. Because when unelected individuals are permitted to conduct union business and elected representatives are bypassed, that is not a minor issue. That goes directly to the integrity of the grievance process, the validity of representation, and whether the agreement is being properly applied at all. And if grievances raising these issues are not being advanced through the full contractual process, including arbitration where appropriate, then that raises an even bigger question: whether the system outlined in Section 2.1 is being followed or quietly avoided. And that's not a constitutional problem. That's a contractual one, because Section 2.1 doesn't leave room for improvisation. It leaves a record. And just to clear up the narrative, I already provided an explanation of where in the 99 to 05 compiled CBA cites the new tech agreement. The link will be provided in the description for anyone who didn't see it. But you should be honest. The arbitration award you partially presented for the Insight app was not a complete win. The arbitrator explicitly upheld management's right to implement the system while only requiring continued negotiations on impact. That is, by definition, a split decision, not a complete contractual victory. Because a real win doesn't leave management exactly where they want it to be. It changes something. And this really didn't. And getting something we were already entitled to years after implementation and only for one department isn't a win. It's delayed compliance. Technically, that's just catching up, and only partially. And let's address something else, because I caught that too, 𝕬𝖊. You tried to dismiss my argument by suggesting I'm using technology to craft narratives. But in the same breath, you're celebrating an arbitration outcome tied to the rollout of new technology, funded by union resources, as a victory. So let's be clear. Using tools to access information, analyze it, and present it accurately is not a weakness. That's called being informed. And if technology is acceptable when it's used to justify a narrative, then it doesn't suddenly become a problem when it's used to challenge one. Because the issue isn't the tool. It's whether the person using it can stand behind the accuracy of what they're saying. And respectfully, Mr. 𝕬𝖊, that's where your argument falls apart, not mine. Peace and blessings, guidance and protection.